Water, water everywhere, nor any drop to drink. And if I remember, that will become relevant. But two bits of defamation news for you. One that I was asked to do, this is that Bridgen and Hancock case, the two MPs embroiled in a defamation case. And also, can a trade union sue for defamation? Spoiler, yes they can, but I'll try and pad it out a bit. But the first one, what's this Bridgen and Hancock? Assuming I'm getting the names right. I did try and remember this. I was going to write it down, but I'm quite useless. But anyway, a Tory MP stood up in Parliament and made a speech about the vaccination programme. And it's fair to say he was not in favour of it. And he described it as the biggest crime against humanity since the Holocaust. Matt Hancock, former Health Secretary, he later on at PMQs, he said to the Prime Minister, would you agree that that's a terrible thing to say? And the Prime Minister said yes. But Mr Hancock later put out a tweet and he said, it's shocking that a sitting MP should say things like this and engage in anti-vax, anti-Semitic conspiracy thinking. And he linked to his exchange at PMQs, but not to Mr Bridgen's original statement. But Mr Bridgen sued for defamation, and he claimed that the allegation was that he was anti-Semitic. So there was what we call a meaning hearing. And as I've explained before, this is a preliminary hearing where the judge determines what would your average hypothetical reader, not too prone to scandal, but not naive either, what would they think of it? And the judge looked at this, he just said, I'm just going to look at the tweet, I'm not going to look at any of the background, I'm just going to do it as if I'm scrolling through Twitter and I just see that tweet. So he says, I see this tweet, I see it's linked to a little snip of somebody standing up at PMQs and saying this, but it doesn't say who it's being said about. Now, the fact that Mr Bridgen had also put out tweets himself, he said, well, they weren't linked or anything like that. And there's this idea that, especially with something like Twitter, which is very, very fast moving, the courts tend to say, look, people aren't going to engage in massive research about these things unless they're desperately interested. Your average reader's just going to be doom scrolling through. So they're not going to say, oh, what's all this about? I'll go into the background. So at the meanings hearing, the judge came back and he said, right, here's what I find it means. It means an unnamed MP made some statements about vaccinations that were conspiracy thinking and quoting an anti-Semitic conspiracy. He said that the bit that was actually a statement of fact was an unnamed MP said something about vaccinations. He said and this is a conspiracy theory and anti-Semitic. He said that was opinion. Now what he said was, this specifically is not saying that the person was anti-Semitic. He's saying that this conspiracy theory is anti-Semitic. And you get this idea in defamation that there is a distinction between saying somebody is a racist, for instance, and saying somebody has said something that is racist. Because, it's all about outcome, not intent. So they can say, well, yeah, I'm not suggesting you were racist. I'm just saying what you said has racist connotations. And in a similar thing, they're saying, not suggesting, it doesn't necessarily mean you are anti-Semitic. It's just that this conspiracy theory can have anti-Semitic overtones. But he said that was a matter of opinion. Now, this is clearly one of those judicial shots across the bows, where now that we have, judge-only defamation trials, so we don't have to predict and try and guess what a jury would think the meaning is. You know in advance what the meaning is because the judge tells you. He says this. So this is what you have to defend. Now, it's going to be very easy to defend, isn't it? Because basically the only factual allegation is an unnamed MP said something about vaccinations, and that is true. I mean, there's also the hurdle of, he's saying it's an unnamed MP. Now we get into this very interesting thing, of course, because you can say anything you want in Parliament. Things said in Parliament attract absolute privilege. So you can't sue for defamation for something said in Parliament. But the flip side of that is the courts say, well, if you can't be sued, you also can't put this into evidence. You know, it's tit for tat. It's only fair that if you have immunity from being sued, you can't use your privileged position to try and sue somebody by saying, yes, well, it's clear that he was referring to what I said in Parliament. And the second bit is opinion. Now, the mere fact that something is found to be opinion, I mean, opinion is a defence to defamation, but it's a multi-part test. It has to be an opinion founded on facts, and it has to be an opinion that a reasonable person could hold based on those facts. Not that everybody would, but just that a reasonable person could. But it also has to be that you genuinely hold that opinion. So say, for instance, there is something that it's an opinion a reasonable person could hold, but you're just saying it to be nasty, you don't actually believe that, then that wouldn't be a defence. Although, as you can imagine, it'd be a nightmare to actually prove that state of mind unless somebody actually admitted that they were just saying it just to be scandalous. So what's going to happen now? Well, the claimant, Mr. Bridgen, he doesn't have a lot of choice here. I mean, there'll probably be some negotiations about how do you want to settle this and how much of our costs are you going to pay. But realistically, he can either take this to trial, where he'll inevitably lose, or he can issue what we call a notice of discontinuance. That's an official throwing in of the towel. But the thing, when you serve a notice of discontinuance, you are agreeing to pay the defendant's costs. Usually to be assessed if not agreed. So I'll do one of my mystical predictions. My prediction is this is going nowhere, and we'll probably see Mr. Bridgen either issue a notice of discontinuance, or they'll settle this behind the scenes, and they'll be sort of, okay, here's what our cost is, let's just cut to the chase, give us this, and it'll all go away. So that's news bit number one. News bit number two is quite interesting. A former member of a trade union called Prospect sued the trade. He said something about the trade union, and the trade union said, right, we're going to sue you for defaming us and malicious falsehood. But he applied to strike out the claim. Now, from a legal perspective, what's interesting is he did it under what we call Part 11 of the CPR, which is where you say the court does not have jurisdiction to hear this claim. But usually that is only used when say, for instance, there's litigation and somebody sues somebody, but in the contract there's an arbitration clause saying, before you sue us, you have to go down this arbitration route, or we've agreed that the courts don't deal with this, some trade body does it, or something like that. I've spoken before about the Arbitration Act, where in advance of any fallout and potential litigation, the parties can agree that rather than let the court sort it out, they'll go down some alternative dispute resolution track. So if that is agreed, then you do tick the box on the acknowledgement of service saying we challenge jurisdiction, and then if the other side want to fight that, then you do use Part 11 and say, I'm sorry, court, you can't even entertain any aspect of this claim because we have agreed that the courts can't hear it and it's to be dealt with elsewhere. But what the court said in this case is, well, actually, no. What you're doing is you're applying for a strikeout, and there's no the court said, we do have jurisdiction to hear this argument. We're not saying that we agree that trade unions can sue. We're just saying that we are the appropriate body to have that argument in front of. Now, I must confess, when I saw this at first glance, I thought, I don't think it's unreasonable to actually have gone down the Part 11 route, but I can see why the court said go down what we call the Part 3.4 route, which is applying to strike out. And he applied to strike out. He said, trade unions don't have an individual identity of their own, so they can't be defamed. I mean, corporations can be, because corporations are what we call legal persons. In law, you have natural persons, like humans, and you also have legal persons, like corporations. And people like me are also arguing that, animals should have personhood, and indeed landscapes and trees and all that sort of thing. I'll give a shout out to Paul Pousland here. He does a lot of really good sort of campaigning work on this, and we don't agree on everything, me and Paul, but that's something we certainly do agree on. So if a company can have personhood, why can't an animal? But there you go. But anyway, but trade unions aren't incorporated. They're unincorporated associations. But they looked back at the history of trade unionism, because we used to have what we call the Combination Acts that said if a bunch of people combine together to frustrate a contract, say for instance by all saying, right, we'll not turn up to work the next day, then that was seen as a form of conspiracy. And actually trade unions were then given immunity from that. They said, okay, we recognise the need for trade unions, so you can't sue just because trade unions, a bunch of people get together and say we're going on strike. However, that meant trade unions could neither sue nor enter contracts in their own right. So, when they started getting headquarters and things, it was like, well, we need to rent a photocopier. Well, who's going to do that? We can't do it in our own name. So they actually introduced a law saying trade unions, although they're not incorporated bodies, they do have standing to sue and be sued in their own right. And in this case, the judge has said, well, that seems to imply, it says, so it doesn't limit, what causes of action. So I'm going to say that applies, and yeah, a trade union can sue for, defamation and malicious falsehood. He wasn't saying that, they'll definitely succeed. He just said that is the, something that is permissible, because this was just a preliminary argument to try and get the case struck out. So that will presumably go to trial, or probably, possibly settle. We'll see. But there you go. So that's the latest in defamation. Where am I today? I'm in Watch It in Somerset. And the reason I did that is, of course, because there's Watch It Harbour behind me, which I was going to film at, but the tide's out and it just looks really scruffy. It's just for like diesel and old oil drums and stuff. But famously, this was meant to be the inspiration for the Rime of the Ancient Mariner, the guy who shot the albatross, which he shouldn't have done, and it brought him all bad luck. It might not have been the inspiration, because Coleridge kept saying, well, I'm pretty certain that's where I went and that was the inspiration, but some other people have said, well, no, one of your mates wrote a story that's pretty much you just ripped off and you appear to have conveniently forgotten it, like he did with all that stuff like, oh, I wrote the best poem in the world, and then some guy from Porlock turned up and disturbed me and I forgot it now, so it's all his fault. But trust me, it was a brilliant poem, and it wasn't just that I was off my head on opium and I can't remember what I was doing. So there you go. As always, hope you found that vaguely useful, vaguely informative, vaguely entertaining, vaguely accurate, all that sort of thing. If you did, please consider liking, sharing, subscribing and all that YouTube nonsense.